Hey everyone, welcome to Localism, the podcast that asks if we're putting our power in the right places. I'm your host and guy who doesn't really like Tootsie Rolls that much, because I think they're gross and I'd rather have chocolate, Blunchley. In today's episode, we ask what I think is a pretty damn interesting question. Is direct democracy legal in America? Answering that question will require us to learn about an American Civil War, no, not that one, the Federalist Papers, and Oregon getting sued by a telephone company in the 1910s. I gotta tell you folks, I'm obviously biased, but I think this is maybe the coolest and most generally engaging episode Localism has done yet. And if you're someone who hasn't listened to past episodes and maybe isn't all that interested in the concept of localism in general, I still think you'll find a lot to learn in this episode. Strap yourself in, and let's all learn about the Guarantee Clause together. So last episode, I kind of waxed poetic about this idea of a proxy-based, directly democratic system that local governments could adopt to become more representative and accountable to the people they serve. This system would work just like a normal direct democracy, except that members of the community could choose to delegate or undelegate proxies at will. These proxies would exercise their own votes, plus any votes delegated to them. My theory is that this would enable the responsiveness and universality of direct democracy, while allaying pragmatic concerns by reducing the number of people who actually need to have their butts in chairs to vote on stuff. Since the whole project of localism is to give local governments more authority, I argue that proxy-based direct democracy was an important system to adopt, as otherwise devolving authority to local governments would just entrench all of the bad dynamics that currently make local government fail to reflect community interests. And that's all well and good, but it doesn't change the fact that proxy-based direct democracy is still a form of small d democracy. And that could be a bit of a problem, because there is a provision of the federal Constitution that, at first glance, appears to make democracy illegal in America. I'm talking about Article 4, Section 4 of the Constitution, the federal Constitution, which provides, "The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion, and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence." Sorry to any of my conservative listeners, but this doesn't mean everyone in America is required to be in the Republican Party. The Republican here instead refers to a republican form of government, or a form of government in which citizens are ruled by a slate of elected representatives. The federal government is itself a republic. We vote for congressional officials that then go on to act in our name, if not always in our interests. Article 4, Section 4 of the Constitution is called the Guarantee Clause because of the language in it that says America will guarantee every state a republican form of government. So let me paint a hypothetical picture for you. Let's pick on, let's do Alaska today. Suppose Alaska undergoes a series of state and local level reforms that make Alaska a localist state. Alaska adopts the reformist model of localism, which is to say it adds a state-level 10th Amendment to its state constitution that makes the state government only able to exercise those powers directly delegated to it from local governments. It also provides the carve-out of matters of local concern, within which local governments may legislate without the possibility of preemption by the state government. Lastly, Alaska adds a provision to its state constitution that authorizes local governments to adopt proxy-based directly democratic systems if the citizens of those local governments so choose. Suppose further that Alaska citizens in the city of Juneau, oh shit, hold on, I better go look up and make sure I'm actually pronouncing that right. Okay, we're so fucking back. Yep, it is Juneau. Sorry folks, I'm not like an Alaska expert. Anyway, suppose that Juneau holds this vote with all of its citizens, and all the citizens come together and amend their city charter such that the city will now be operated as a proxy-based direct democracy. It's a close and very contentious issue. 51% of the city votes in favor of proxy-based direct democracy, 49% vote against. After the debate, passions are running very high. A woman who voted no on the conversion to direct democracy happens to be reading through the federal Constitution, as one does, and finds the Guarantee Clause. She thinks to herself totally reasonably, hey, wait a minute. The state of Alaska passed this law that let local governments become direct democracies. But the Guarantee Clause says that the federal government has to guarantee that all states are republics, not democracies. So shouldn't it be unconstitutional for Alaska to pass a law that allows parts of itself, local governments, to become direct democracies? This enterprising woman subsequently filed suit in the United States District Court for the District of Alaska, seeking to enjoin the part of the Alaskan law that allows local governments like Juneau to convert into direct democracies. How might this lawsuit turn out? Would the woman win and the Alaska law permitting democracy be enjoined? Or would the courts find that this is something Alaska is allowed to do? And here's a little more detail to this hypothetical. Suppose instead of turning to the courts for redress, the woman instead writes a letter to her senator, her federal senator. She tells the senator that this law in Alaska that permits direct democracy is a terrible idea, and she'd like the federal government to do something about it. Congress doesn't like the fact that local governments are trying to do more on their own, so Congress passes a law that bans state governments from allowing their local governments to become direct democracies. Congress claims that the Guarantee Clause allows it to pass such a law. Is Congress right? Answering these questions is pretty hard, and I'll tell you straight up, I don't actually have a clear, definite answer to give you. But maybe we can get an idea based on what the founders might have intended the Guarantee Clause to mean, and how the Supreme Court has interpreted the clause on the relatively few times it's come up in Supreme Court cases. Let's start with those old wig-wearing windbags, the Founding Fathers. As it happens, the Founding Fathers wrote pretty extensively on their opinions of democracy, and specifically democracy versus republicanism. And those thoughts were transmitted in what are called the Federalist Papers. The Federalist Papers are a collection of essays written by Founding Fathers like James Madison, John Jay, and Alexander Hamilton. The essays were written in the aftermath of the Constitutional Convention, and they were disseminated in the hopes of convincing voters in the fledgling country of America to ratify the proposed Constitution. Each essay is referred to by a number, so for example Federalist number 13 or Federalist number 72, and there are 85 essays in total. The Federalist Papers provide a really unique avenue into the opinions and intentions of the men who created America's governing document. As such, they are treated with special reverence by the federal courts, and especially the Supreme Court, who will often turn to the Federalist Papers in order to figure out what the founders' intentions were regarding the Constitution. There are several Federalist Papers that discuss republicanism and what characteristics a government needs to have in order to be Republican. One even directly discusses the Guarantee Clause. In Federalist number 43, Madison reproduces the text of Article 4, Section 4, and then argues that the provision is warranted because, quote, in a confederacy founded on Republican principles and composed of Republican matters, the superintendent government ought clearly to possess authority to defend the system against aristocratic or monarchical innovations. All that Madison mentions are aristocratic and monarchical innovations. Democratic innovations are conspicuously absent. Maybe this could suggest that Madison understood Article 4, Section 4 as giving the federal government the power to step in if a state was backsliding into aristocracy or monarchy, the kind of rule that America had just fought a war to liberate itself from, rather than keeping the state from pursuing more democratic forms of government. Later in Federalist number 43, Madison arguably reiterates this conception of Article 4, Section 4 as being permissive of non-monarchical and non-aristocratic innovations within states. Whenever the states may choose to substitute other Republican forms, he writes, they have a right to do so, and to claim the federal guarantee for the latter. The only restriction imposed on them is that they shall not exchange Republican for anti-Republican constitutions, a restriction which, it is presumed, will hardly be considered as a grievance. Of course, Madison's words here seem to focus on innovative, different forms of republicanism rather than innovation more generally, and he does not clarify how to draw the line between Republican constitutions and anti-Republican constitutions. In Federalist number 57, the author, either Madison or Hamilton, we don't know, firmly declares that the elective means of obtaining rulers is the characteristic policy of Republican government. Since a state organized along proxy-based directly democratic procedures would no longer elect rulers, and instead would govern on the basis of votes submitted to a popular assembly that included all citizens directly governing themselves, that democratic governance would seem to lack the essential character of republicanism as defined in Federalist number 57. In Federalist number 14, Madison responds to critics of the proposed Constitution who were worried that the country was physically too big to effectively be governed by a shared Republican government. Man, who knows what those critics would think today when the country has grown way bigger than anyone at the time could have possibly thought it could. Anyway, Madison says that these criticisms about America being too big to be governed have been refuted in earlier papers. Great, thanks, very helpful. But nevertheless suggests that the idea that America is too big for republicanism is driven chiefly by, quote, the confounding of a republic with a democracy, applying to the former reasonings drawn from the nature of the latter. Madison then goes on to differentiate the two. In a democracy, the people meet and exercise the government in person. In a republic, they assemble and administer it by their representatives and agents. A democracy, consequently, will be confined to a small spot. A republic may be extended over a large region. This suggests that proxy-based direct democracy could be somewhat Republican in Madison's eyes. A proxy is not a representative in the sense that they are not selected via election to serve out a defined term. Basically, they're not elected officials like senators and members of the House. Instead, an individual, just on an individual one-to-one basis, delegates their vote to someone else. That's very different than being elected as a representative. A local government organized along proxy-based, directly democratic procedures will almost always involve a mixture of people showing up in person to directly cast their votes themselves and proxies showing up to cast their votes on behalf of other citizens. Depending on the community, proxies may even make up the majority of attendance at the assembly's regular meetings, and therefore the local government will be an institution where the citizens' agents have assembled to administer the government. Thus, proxy-based direct democracy may arguably be sufficiently Republican, at least as Federalist Number 14 is concerned. I have a feeling, though, that this argument is a little too cute to actually be persuasive. Okay, so the earlier papers referred to in Federalist Number 14 include Federalist Number 10, wherein Madison promotes the advantages of a constitution that prevents the rise of factionalism. Factionalism is something that the Founding Fathers were super worried about, and Federalist Number 10 is likely the most anti-democratic of all the Federalist papers. Madison accuses democracy of being especially susceptible to factionalism and republicanism as a preferable alternative. As in Federalist Number 14, Madison defines a, quote, pure democracy as a society consisting of a small number of citizens who assemble and administer the government in person. The use of the qualifier pure here is interesting. Madison appears to acknowledge the possibility of non-pure forms of democracy that have some characteristics of other forms of government. Could that include a democracy with some Republican features? A republic is instead, quote, a government in which the scheme of representation takes place. Accordingly, to him, the biggest differences between a democracy and a republic are, first, the delegation of the government in the latter to a small number of citizens elected by the rest. Secondly, the greater number of citizens and greater sphere of country over which the latter may be extended. According to Federalist Number 10, a pure democracy can admit of no cure for the mischiefs of faction. A common passion or interest will, in almost every case, be felt by a majority of the whole. A communication and concert result from the form of government itself, and there is nothing to check the inducements to sacrifice the weaker party or an obnoxious individual. This preoccupation with the danger of passions gripping a government premised on majoritarian rule strongly indicates that Madison would want to avoid government via proxy-based direct democracy. He speaks in admiration of the ability of a republic to, quote, refine and enlarge the public views by passing them through the medium of a chosen body of citizens whose wisdom may best discern the true interest of their country. Yeah, remember in the past episode when I said the real reason we had a smaller Republican government was because the founders wanted to keep the stinky masses out of the halls of power? This is what all that shit about the wise and chosen body of citizens is about. And shortly thereafter, and perhaps the most damaging statement thus far for the idea that the Founding Fathers would tolerate democratic state-level governments, it may well happen that the public voice pronounced by the representatives of the people will be more consonant to the public good than if pronounced by the people themselves convened for that purpose. A local legislator operating along proxy-based, directly democratic procedures is nothing if not a place where citizens convene in order to pronounce the public voice themselves rather than via an elected representative. So what are we to make of all these old scribblings from the Founding Fathers? Well, I don't think there's much of a way around it. The Founding Fathers were not at all fans of direct democracy. They had a vision of America as a small r Republican nation, which they believed was a more just and equitable version of government than monarchy or aristocracy, but still sufficiently place power in the hands of a few chosen men who would then exercise their huge brains to govern on behalf of the good of the stinky dumb pores. Sure, maybe by specifically adopting a proxy-based form of direct democracy, a state or local government could blur the line a little bit between direct democracy and republicanism, such that it might technically meet the definition of republican as laid out in some of the Federalist Papers. But in general, it's clear that the Founding Fathers considered democracy to be antithetical to the character of the nation they had just played a role in birthing. And in light of that view, we might reasonably expect the Guarantee Clause to broadly bar states from undergoing small d democratic innovations. Right? Well, here's where things get even more complicated. To my knowledge, in all the years since the nation's founding, the Supreme Court has never relied on the Guarantee Clause to quash a state's attempt at democratic reform. Not once. In fact, as we'll see in just a little bit, the Supreme Court's position is that it actually lacks any authority to rule on whether a state or local government is democratic versus republican. Let's look at a few cases where the Supreme Court had a chance to share its thoughts on the Guarantee Clause. Fortunately for us, these cases have some super interesting fact patterns, so this hopefully will be entertaining even separate from any lessons we learn about the Constitution. Our first case, Luther v. Borden, involved a tense and largely unsung historical incident in Rhode Island. When Rhode Island entered America after the Revolutionary War, it alone of all the former colonies did not adopt a new state constitution. Rhode Island instead chose to maintain its original royal charter that was granted by the British Crown. This royal charter set out a somewhat stringent property requirement in order for a citizen to be eligible to vote. Angered by the Rhode Island state legislature's refusal to take action to expand the franchise, Rhode Island citizens held a People's Convention, where they drafted a new state constitution that allowed more citizens to vote, but still didn't let anyone other than white dudes vote. The People's Convention did not have the force of law, meaning that the new constitution was technically without legal effect, but it still received widespread popular support. Tensions between supporters of the extra-legal constitution and the officials of the state government grew to the point that citizens actually engaged in armed rebellion. The whole incident was called the Dorr Rebellion, named after Thomas Dorr, a central figure in the drafting of the more democratic state constitution. In the midst of the Dorr Rebellion, a Rhode Island official named Luther Borden searched the property of one Martin Luther, a Dorrite who Borden ended up arresting. Luther then brought a civil suit against Borden for trespass. The case made its way up to the Federal Circuit Court. In the course of deciding the case, the Circuit Court instructed the jury that the People's Convention Constitution had no legal effect, and that Rhode Island's charter remained the state's governing document. Luther, when he brought this case to the Supreme Court, specifically accepted to this conclusion, claiming that instead, the People's Convention Constitution was the one that should be considered as in effect. The Supreme Court, therefore, was required to determine which constitution, the popular extra-legal constitution or the old royal charter, was in effect. This in turn caused the court to explain how Article 4, Section 4 bore on the dispute, and whether the requirement that America guarantee the states have republican forms of government could render Rhode Island's charter illegitimate. The theory here was that, well, this property requirement that's attached to the ability to vote is essentially not republican. And since that property requirement is set out by the Royal Charter, it must be the case that the Royal Charter isn't the one in effect. Because if it was in effect, then Rhode Island wouldn't be a republic, and that would go against the Guarantee Clause. The court disposed of this issue and the case as a whole in a kind of surprising way. Rather than make any ruling on the merits of which of these constitutions is in effect, which of these constitutions is or isn't republican, the court instead held that whether or not a particular form of government was republican, as required by Article 4, was a political question, and thus was not an issue that federal judges had the authority to rule upon. Instead, Article 4 allowed the Congress to decide whether or not a state had a republican form of government, and that Congress's decision was final, no judicial review allowed. Since Congress had admitted senators and state representatives elected pursuant to the Royal Charter to the federal Congress, the court surmised that such admissions amounted to an acknowledgement that the Royal Charter did indeed create a republican state government. Congress had deemed the Royal Charter as sufficiently republican, and the federal judiciary had no power to disturb that judgment. This was an exercise of what's called the political question doctrine, which is a legal principle that if a legal issue essentially just turns on a purely political judgment, then the federal courts will refuse to resolve the issue. The idea is that these political questions are so bound up in politics rather than law that if a federal court took them up, it would create separation of powers issues, as the court would basically be wading into political processes that instead should be left to Congress or the voters. The result in Luther v. Borden was basically the court looking at the question of whether or not Rhode Island's charter was Republican and going, shit, man, no matter how we come down on that question, we'd basically be making a purely political judgment. That's not our place. It looks like Congress let Rhode Island be a state by admitting it, so we guess that Congress deemed Rhode Island's charter sufficiently Republican that admission was no concern. We are not going to interfere with that judgment. So yeah, not still super clear what does or doesn't make a government Republican for guarantee clause purposes. And our next case still isn't going to provide an answer to that question. Pacific States Telephone and Telegraph Company versus Oregon came around 60 years later in 1912. It came about thanks to Oregon being based, yet again, in making its state government more small d democratic. This should not surprise anyone who listened to the Home Rule episode and remembers that Oregon is, I'm pretty sure, the only state in America that lets local governments pass and amend their own charters. In 1902, Oregon had amended its state constitution to add a provision that drastically altered the way laws could be passed in the state. In relevant part, that provision read, "The people reserve to themselves power to propose laws and amendments to the Constitution and to enact or reject the same at the polls, independent of the Legislative Assembly, and also reserve power at their own option to approve or reject at the polls any act of the Legislative Assembly." This is very clearly a democratizing amendment. This constitutional amendment was basically saying, if we go through the right processes, the people can exercise their popular sovereignty directly to override an act by the state legislature. The people can decide what the law is, even if their elected representative says something else. That gave ultimate power to the people. And as we just learned, looking through all the Federalist Papers, ultimate power adhering to the people rather than up to elected representatives sounds a whole lot like the kind of democracy that the Founding Fathers did not want to allow in America. So, okay, Oregon adds this democratizing amendment to its constitution. The amendment gave the state's citizens the power to pass any law or override any law passed by the state legislature. The citizens could accomplish this by submitting a law or amendment to a popular statewide vote. A simple majority would be enough to pass a law or override one of the state legislature's laws. Pursuant to this power, in 1906, the people of Oregon utilized a popular vote to pass a law that imposed new taxes on the then new telephone and telegraph companies. One of the companies covered by this new tax was the Pacific States Telephone and Telegraph Company. Pacific States was not happy about having to pay this new tax. It was so unhappy that it refused to pay it and was taken to court by Oregon for delinquency. As part of its defense against why it shouldn't have to pay this tax, Pacific States argued that the new tax was unconstitutional under the Guarantee Clause. Its theory was that the new democratic provision in Oregon's state constitution was so democratic that it effectively altered Oregon's form of state government to be non-Republican. It was then these non-Republican processes that had been used to pass the special tax on telephone and telegraph companies. Accordingly, Pacific States argued that the law was illegitimate as it had been passed pursuant to a democratic form of government which the Guarantee Clause outlawed. This case eventually makes its way up to the federal Supreme Court. So does making your state more democratic violate Article 4, Section 4? The court again didn't give us much in the way of a definitive answer. In fact, it again refused to provide any answer at all. Writing for a unanimous court, Justice White began his analysis by expressing his concern that directly taking up the question of whether a state was sufficiently Republican would represent a terrifying expansion of judicial power. He worried that if the court allowed itself to hear cases like Pacific Telephone, the court might end up sometimes finding that a state's entire form of government, or even the state's mere existence, was unconstitutional. Then, to prevent matters in the unconstitutional state from falling into total chaos, the court would have to impose some new temporary form of appropriately constitutional government. Justice White was, in my opinion, rightly uncomfortable with a bunch of unelected lawyers in robes being the ones who destroy and then rebuild a state government of their own volition. The court thus held that whether or not Oregon's democratic constitutional provision, and the broader question of what is or is not a sufficiently Republican form of government for the purposes of Article 4, Section 4, was simply the kind of question that the court should not rule on. So the court dismissed the case on the basis that the court lacked jurisdiction. The court referred back to Luther v. Borden as setting out the principle that the courts should stay out of deciding whether or not states are Republican. The court actually thought that Luther settled the issue outright, calling it the leading and absolutely controlling case for how to handle Article 4, Section 4 disputes. So if the dweebs in robes don't get to decide, who does? According to the court in Pacific states, the dweebs in Congress. Just like the court in Luther, Justice White held that the power to decide whether or not a state was Republican for the purposes of Article 4, Section 4 is, quote, embraced within the scope of the powers conferred upon Congress and not therefore within the reach of judicial power. So Oregon's democratic state constitution stayed in place, and Pacific Telephone was sent packing and told, pay your tax. Congress took no action to deem Oregon a non-republic, and subsequently, democratic changes to state constitutions spread to other states, especially western states like California. Those provisions, albeit with modifications that explain the referendum and initiative process in greater detail or set out new requirements, generally survive to this day. So what are we supposed to make of this kind of puzzling line of guarantee clause cases? Taken in their least favorable light, they appear to enable Congress to decide solely of its own volition whether a form of government violates Article 4, Section 4 because it is insufficiently Republican. The federal courts would be powerless to step in and find that Congress had erred in its determination that a state's form of government was non-Republican or lacked the authority under the Guarantee Clause to act. But on the flip side, it's not super clear from the cases what congressional powers the Guarantee Clause actually grants to Congress. The only power we know for sure, at least as I read the cases, that Congress has under the Guarantee Clause is the ability to vote on whether or not to admit new states to America. If Congress admits a new state, then that admission involves an implicit recognition that the state's form of government is small r Republican for the purposes of the Guarantee Clause. That's what happened with Rhode Island in the Luther v. Borden case, and why this royal charter that set up this pretty un-Republican-looking property requirement was still nevertheless deemed to be a sufficiently Republican form of government. But it's not like the Supreme Court ever said that Congress doesn't have broader powers in this area. It's just that admission is the one definitive it's ever held up of Congress exercising powers pursuant to the Guarantee Clause. The non-justiciability of Guarantee Clause issues creates some pretty scary possibilities for the project of localism and, not to be dramatic, for the country as a whole. For example, what if Congress woke up tomorrow and passed a law that said something like, pursuant to our authority under the Constitution's Guarantee Clause, states are hereby banned from altering their form of government to become democratic. Any attempt to implement direct democracy constitutes a crime and renders the state's elected officials subject to imprisonment of no less than 10 years. Then Congress goes and arrests the members of a state legislature who voted in favor of a law allowing local governments to operate as direct democracies. Or, if we really want to put on the tinfoil hat, just any law that Congress doesn't like and that alters the way that a state government works. The state legislatures are obviously going to want to fight back, and they're going to sue the government in federal court. But how would you actually challenge this law, saying you can't make your states have different forms of government because doing so would make them more democratic and thus violate the Guarantee Clause? Well, maybe you could argue that there isn't anything in the Constitution that permits Congress to criminalize elected officials in the way that the law does. Remember, the law says if you implement direct democracy or attempt to do that, and that renders a state's elected officials subject to imprisonment of no less than 10 years. In response to this argument that, well, wait, the Guarantee Clause doesn't say anything about criminalization, Congress points to the Constitution's Necessary and Proper Clause, which allows Congress to exercise all means necessary and proper for executing the powers the Constitution grants Congress. Congress argues that in order for its power under the Guarantee Clause to have any teeth, it needs to be able to back up the guarantee of republicanism with enforcement authority. Otherwise, it won't have the ability to deter states from straying from the Republican form of government, and won't have any real authority to stop states that do adopt a form of government other than republicanism. Like, if a state suddenly changed its form of government to be a monarchy and appointed a king, how is Congress supposed to enforce its guarantee that that won't happen if it can't arrest the person who's trying to be king? Thus, the power to criminalize behaviors that render states non-Republican is, at least according to Congress in this hypothetical case, necessary and proper in order to exercise Congress's power under the Guarantee Clause. Now, I am not saying that this argument has any merit. I'm just raising it as a possibility. I genuinely don't know what the federal courts would make of such an argument. My understanding is that necessary and proper issues are extremely difficult and complicated, so I really have no idea if this would hold any water. But from my purely amateur perspective, for what it's worth, I can't completely discount the idea that the federal courts would accept the idea that Congress could criminalize actions that rendered state governments democratic rather than Republican. Okay, so maybe instead the arrested state legislatures tried to argue that the changes they passed, whatever those changes are, didn't actually make the state a democracy as the founders would have defined that term, and as a result, the state is still a republic, and there's no basis to arrest the legislators who implemented the change. This is basically saying, hey, look, federal court, we didn't make our state into a directly democratic state. It's still a republic. But it's established under Luther v. Borden and the Oregon Pacific Telephone case that a court can't even address this argument. Whether or not a particular form of government is a republic or a democracy is a political question that federal courts have no authority to address. So the Supreme Court would just rule that under the political question doctrine, it can't resolve whether the state is a democracy. This means that the court couldn't say that there was no basis to punish these state officials, because in order to determine whether or not that basis existed, it would first have to determine whether or not their actions created a form of government that wasn't Republican, and that's not something the courts can address. So, in this kind of harebrained hypothetical what-if scenario I've come up with, which, to be clear, I mean, we're really out on a limb here, but the upshot of this potential scenario is that Congress could maybe just wake up one day, declare that a government with certain kind of characteristics is democratic or just un-Republican, and then start arresting or otherwise penalizing public officials that implement or maintain that form of government that Congress deems violative. Independent of how bad that is for the project of localism, that's just kind of a scary thought in general. And again, to reiterate, if Congress claimed that it was exercising its authority under the Guarantee Clause, and that it was doing so because a state's form of government was not Republican, the court couldn't actually look to see whether or not that state was Republican because it's a political question that the court wouldn't reach. Or, maybe all of this is a little bit too tinfoil, even for me. The Guarantee Clause is a pretty obscure provision of the Constitution. Unless you're a lawyer, I'm willing to bet that before you started listening to this podcast, you probably didn't even know there was something in the Constitution that said that the federal government had to guarantee states a Republican form of government. It could be that Congress wouldn't be all that interested in exercising power under the Guarantee Clause or trying to figure out what it could or couldn't do under that clause. Maybe federal courts would find that in the situation where Congress was trying to interfere with what form of government the states were adopting, by arresting or penalizing people, that presents a question that is not a purely political question, and so the courts would actually step in and say, hey, you can't do this. Maybe Congress wouldn't care all that much about whether or not a state starts having its local governments, not the state as a whole, but just some of its local governments run on a directly democratic basis. Though what Congress does and doesn't care about is extremely difficult to predict, so who knows? And there's also some reason to think that the reforms localism seeks to implement wouldn't even raise any Guarantee Clause issues to begin with. Let's start with what I call the absolute model, which was the model of localism that seeks to turn the pyramid of preemption completely upside down by making local government the highest form of authority in America, save for the individual liberties granted by state and federal constitutions. Implementing that form of government would require amending the federal constitution anyway. So if the movement towards the absolute model of localism also wanted to make local governments be operated as proxy-based direct democracies, well, then it could just amend the Guarantee Clause what was in the neighborhood to say, nothing in this clause should be construed as limiting the ability of local governments to adopt directly democratic forms of government. Just while they were in the neighborhood. Then there's the reformist model, which instead of turning the pyramid of preemption all the way upside down, It's a little more complicated and involves passing a kind of state-level 10th Amendment that says state governments can only exercise those powers that have been directly delegated to them, and all other powers are reserved for local governments. And also involves a robust matters of local concern carve-out within which local governments can legislate without being preempted by the state. While that changes the scope of a state government's authority, that doesn't actually change anything about the Republican nature of that state government. The state legislature in a reformist localist state would still be full of officials elected by voters in the normal Republican way. That Republican form of state government would remain, even if citizens and local governments exercise their new authority to make their local governments become direct democracies, proxy-based or otherwise. Lastly, a close comparator to localism's idea of directly democratic governance is the New England Town Hall, which is this practice that several localities in that part of America observe, where ordinary citizens show up and vote on local legislation or other matters. It's a true one-person, one-vote system, though the power of such town halls are often limited to very narrow matters, or can be overridden by actions at other levels of government, or are held only about once a year, meaning they aren't quite as hardcore as localism, which provides for expanded local authority plus full direct democracy. But while the New England Town Hall may not be an exact one-to-one with proxy-based directly democratic procedures, it still represents a form of government that looks a whole lot like a democracy rather than a republic. Despite this, there has never, to my knowledge, been an attempt by the federal Congress or the federal courts to interfere with these New England states and local governments by claiming their democratic nature renders them open to guarantee clause concerns or federal level interference. And it's not like these New England town hall meetings are some new innovation that no one has gotten around to litigating about yet. New England local governments have been holding these kind of town hall meetings before America was even a country. And for what it's worth, it's not like once America was formed, the federal Congress went to the New England states and said, hey, you need to cut that shit out. Everyone has to be a republic now. Plenty of the founders were from New England and were aware of the practice of governance via democratic town hall, and yet the practice continues, to this day, unburdened by the founders' decision to add the guarantee clause to the Constitution. Surely that counts for something when we're theorizing on how the guarantee clause does or doesn't limit local governments from adopting directly democratic procedures, right? But maybe you're joining me in the land of tinfoil and are concerned about the challenges the guarantee clause might pose to making local governments direct democracies. You don't want to go through all the trouble of achieving those reforms on the local level, and to be clear, it would require a lot of trouble, only for the federal government to use it as an excuse to come and fuck around in your backyard. You might ask, are there any approaches that we could use to try and make things more democratic at home, while also arguably not straying from the definition of a republic as it's used in the guarantee clause? Well, one answer is just to drop this silly idea of proxy-based direct democracy outright, and instead make localism solely about expanding local authority via the absolute or reformist models of localism. Remember, like I said last episode, this is not an all-or-nothing venture. I think in America where small R Republican local governments have more power is still better than the current system. The safest way to avoid guarantee clause problems would just be to cut off the democratizing half of localist efforts and focus solely on expanding local authority, then place that expanded authority in the hands of a traditional elected city council or town council or county board of commissioners or whatever. I think that democratizing local governments is an important and worthwhile goal that should be pursued alongside expanding local authority. That's why I've spent so much time talking about it. But I recognize that others may feel differently, and that these guarantee clause issues just create more headaches for the directly democratic half of localist efforts. But maybe you really do like the idea of making things more democratic at home. You just want to see if there's any way we can do that while still remaining a republic on paper. Well, I do have an idea. I'm not sure how viable it might be, but I'll still raise it here and leave the merits for you to decide. Here's the plan. A bicameral local government. By bicameral, I just mean a local government that has a legislature with two sections or groups rather than one. The most common small R Republican form of local government, that's ruled by a town council of like 5 to 7 people, is a unicameral legislature. The only group in the legislature is the town council itself. Now, when you think bicameral legislatures, the first thing that probably pops into your head is the federal Congress or your state legislature, except if you're one of the based people living under the Nebraska unicameral state legislature. To be clear, I am most definitely not suggesting we suddenly create a Senate and House of Reps for your local government. That would still create all kinds of problems while fundamentally being a purely Republican government without any democratic element. Instead, The local unicameral legislature will be divided into two groups. The first is what I'm calling the town council. The second is what I'm calling the popular assembly. Let's start by explaining the popular assembly. That group is going to be the group that has legislative authority. It will exercise that authority along proxy-based directly democratic principles. It will meet regularly to debate and deliberate and vote on legislative matters. This is basically just what would constitute the entire legislature if we weren't trying to duck the guarantee clause by adding an extra element that provides a Republican tinge. That extra element is the town council. It has, let's say, 5 members. These members are elected in local elections that take place every 4 years. They are unquestionably elected officials. The town council has a very limited role in the legislature. Its sole job is to sign off on the legislation that the popular assembly passes. The town council has no ability to propose legislation, to cast votes, or to set agendas. It also has no authority to decline to sign off on any given law. This is not a presidential veto situation. But more on that in a second. If a law gets passed by the popular assembly, the town council has to sign off on it. No ifs, ands, or buts. If you were speaking frankly, you might say that the role of the town council is purely ceremonial. But if you were speaking politically, say because someone in Congress or the federal judiciary is trying to get you to explain why your state allowing this form of local government doesn't create guarantee clause issues, you would say that the presence of the town council renders your local government small r Republican. After all, under your processes, a law cannot be passed until the town council takes action. And that town council is comprised of public representatives who are freely elected by the citizenry to fulfill a legislative responsibility on the citizenry's behalf. Laws can't be passed absent the approval of elected representatives exercising public power on behalf of voters is literally the definition of a republic, right? Maybe just adding this ceremonial town council on top of the de facto fully in control popular assembly would be enough to make proxy-based direct democracy sufficiently Republican for the guarantee clause's purposes. But there's also a chance that a judge or a senator or whatever would look at this and think it's a bit too cute. Like, sure, there's technically elected officials involved in the lawmaking process because the town council has to rubber stamp the popular assembly's laws, but if the town council's sole role is just rubber stamping, then who are we kidding? This is still a direct democracy. So okay, maybe we add one more ingredient to this town council plus popular assembly scheme in order to give the presence of the Republican town council some actual oomph. Hopefully, adding this bit of extra oomph will add a discernible Republican element that satisfies a guarantee clause while preserving the local government's otherwise directly democratic character. So what might this element be? Well, we could give the town council exactly one form of authority: veto power. Town council can't propose a law, vote on a law, set the popular assembly's agenda, or otherwise do anything to actively create law. But it can veto a law if a majority of the town council's elected officials vote to do so. That's a very serious form of legislative power. Serious enough that absolutely nobody could say, in my opinion, that the town council is just a ceremonial body. Probably the oomph of this veto power would render the local government sufficiently small r Republican, even if that veto could be overridden by the supermajority in the popular assembly. For example, maybe if 2/3 of all votes cast in the popular assembly are in favor of overriding a veto. But sure, the structure of local government maybe, big maybe, gets around any potential problems posed by the guarantee clause while still allowing the directly democratic popular assembly to have a lot of legislative power. But that doesn't necessarily mean it's a good way to run a local government, just one that doesn't create guarantee clause problems. For one, this town council with veto power plus directly democratic popular assembly structure makes passing legislation so much slower and more cumbersome than either normal unicameral proxy-based direct democracy or even normal small r Republican city council government. And this bicameral sort of Republican system of popular assembly plus town council, first the popular assembly has to get together, set an agenda, deliberate, and then cast their votes on whether to vote. This is already, you have to count the votes, resolve any disputes in the counting, sort out all the proxy authority. The law then goes to the town council, which needs to review the law, deliberate, and cast their votes on whether to veto the law that the popular assembly just passed. And this is already slower than just having a unicameral direct democracy pass a law, they just vote one time, or a normal city council pass a law, they also just vote one time. But if the veto kicks in, then everybody just has to sit around for even longer before we figure out what's going on. The law gets kicked back down to the popular assembly. They have to argue about whether it's worth trying to get a supermajority vote, whether they should try and pass an amended law that addresses whatever made the town council use the vote, or just drop the law altogether. Furthermore, adding a small r Republican town council filled with elected officials recreates a lot of the problems that make moving towards direct democracy attractive in the first place. Since the town council will be full of traditionally elected local officials, the candidates that succeed in being elected will always be the ones who cater the most to those community members who have the time and capacity to vote in local elections, which often have extremely low turnout. As I discussed at great, some might say agonizing, length in the last episode, the ones who have that time and capacity and the ones who disproportionately vote in local elections and participate in local politics are well-off homeowning retirees. So to get elected, the candidates for the veto-holding town council will have to convince these well-off homeowning retirees that their interests will be protected by the actions the town council takes. And then those that are elected to the veto-holding town council have to make good on that promise by vetoing laws that are going to serve interests other than the retirees. The end result will inevitably be a legislature with two houses that are constantly at odds, with the popular assembly skewing more towards the interests of the community as a whole, and the town council skewing towards the interests of well-off homeowners. Thus, the rewards of our efforts to make our straightforward, proxy-based direct democracy a bit more Republican to avoid the guarantee clause is a government that's bloated, slow, overly complex, riddled by infighting, and recreating all the ills of small r Republican government without capturing any of its benefits of efficiency. But hey, at least we avoided a hypothetical problem that might arise under an obscure part of the Constitution that could maybe possibly let the Senate or the federal courts kind of mess with localism's goals of proxy-based direct democracy. Definitely worth, right? Ugh. Normally when I pick a topic for a show and start writing the script, I try to carefully structure things so that each episode is a relatively logical progression of ideas that ends in a discernible takeaway that I can then share with you. The takeaway of episode 2 was, here's what home rule is and why I think it has some problems. The takeaway of episode 5 was, here are the absolute and performance models of localism and how they differ from one another, and etc., for the other episodes. I don't really have anything like that for this episode. I don't have a discussion that produces a neat conclusion. I don't know how the guarantee clause bears on the proposal to adopt proxy-based direct democracy, or whether or not it makes direct democracy lawful in America. I don't know whether the Senate or the courts or some other party could claim direct democracy is illegal under the guarantee clause. And if someone did claim that, I don't know how I could prove them wrong. Remember, we are in truly uncharted water here when we're talking about implementing directly democratic procedures in local government. New England town halls aside, directly democratic governance has never really been tried before in America. We don't know what kind of legal challenges, guarantee clause-based or otherwise, trying to adopt proxy-based direct democracy could provoke. This episode is deliberately provocatively titled, Is Direct Democracy Constitutional in America? I guess at the end here, I ought to give my best answer to that question. Is direct democracy constitutional? The only answer I can give, and the only answer that I think accurately reflects the legal and factual reality as my tiny brain attempts to conceive it, is maybe. Maybe yes, maybe no. And okay, surprise, I really do have a takeaway for this episode, though maybe not as neat of a one as in other episodes. Here's my takeaway. Fuck it. Who cares if the guarantee clause maybe makes achieving direct democracy more difficult? Like I said last episode, direct democracy is an idea whose time has come. Let's just do it. Let's make our local governments more accountable and give our friends, family, and neighbors a direct say in the laws we obey. No more small R Republican intermediaries, no more group of electeds who kowtow to political parties, just us, creating the law with our own hands and at the helm of local governments that have been empowered to let ordinary people engage in self-rule. And if people want to cry foul to the federal courts or the Senate or Mars, fine. Let them. The burden is on them to show why people having more of a say in government is somehow unconstitutional. Let them be the ones who have to put their money where their mouth is and show why the guarantee clause should have anything to do at all with the project of localism. Until somebody succeeds in making that showing, we forge on, trying to make a better world, a better country, and a more fair community. On that note, this episode is almost, but not quite at an end. We have a few housekeeping things that I want to briefly turn to before we say goodbye for real. You may not even remember this, but in a past episode, I had mentioned that I would do an episode on something called the rights paradox. Stupid name, I know. I wanted to do this episode because I wanted to better explain why localism pushed so hard for community control and community consent and the ability for people to engage in self-rule through the most responsive form of government, local government, but nevertheless did not allow local governments to limit the scope of currently existing rights in state and federal constitutions. After giving this episode idea some more consideration, I don't think I really need to do a full episode on this. I don't think it's that controversial of a take to say that state and federal constitutional rights are good, and we shouldn't get rid of them, even if we change who is passing our laws such that local governments have more authority. I don't think there's anybody out there who's going to say, hey, shouldn't we also let local governments get rid of our rights as part of this process? That's just a dumb idea. And if you disagree and think that local governments should be able to mess with your constitutional rights, well, I guess you better go find another show to listen to. Since this is actually more straightforward than I thought it would be, turns out people really like their constitutional rights and it's a popular idea to keep them around, I am no longer going to do a separate episode on this. Instead, I'm going to do a series of 2 episodes on what I'm calling the cases for localism. The first episode is going to be the liberal case for localism, and the second episode will be the conservative case for localism. The episodes will involve me doing my best to look at the proposal of localism from a liberal and conservative perspective respectively, and explaining why I think both liberals and conservatives should view localism as a viable solution to achieving their particular political goals. My hope is to, A, show how this sort of abstract and sometimes kind of out there idea of localism connects with contemporary, more concrete goals and political ideas that my audience might have, and B, to engage a little more with current events instead of turning a blind eye to stuff that is happening in the world and in America right now as this podcast is being released. And I'm also hoping to show that localism is not a left versus right issue. It really is an issue about how you want legal decisions to be made in America and who you think is the best equipped to make those decisions. After all, if there's anything that even the most staunch MAGA conservative and the most lefty blue-haired liberal can agree on, is that they don't like each other. And each person would prefer to decide things without having to take the other's opinion into account. So next time, the liberal case for localism, and after that, the conservative case for localism. If any of this stuff sounds interesting, feel free to consider subscribing to the podcast on Spotify or YouTube. And please do shoot me a question or comment at localistpod@gmail.com. That's localist with a T, not an M, @gmail.com. You can also submit questions through our website, localistpod.net. Thanks, everyone. See you next time. A huge thank you to Kevin MacLeod for letting me use the 2 songs in this podcast, Acid Jazz and Opportunity Blocks. You can find these and a bunch of other really great songs on Kevin's website, incompetech.com. And the use of Kevin's music here is licensed under Creative Commons by Attribution 4.0.